Hello, everyone. Welcome back to our season 3. Today, we are deeply honored to host Mr. Mohan Sharma, a distinguished member of the Delhi Higher Judicial Service, whose career spans more than 3 decades across the bar, the bench, academia, mediation, arbitration, and public institutions. Sir began his journey as a first generation lawyer, practicing independently for over a decade before entering the judicial services. Over the years, he has served in a wide range of judicial capacities, including additional district judge, presiding officer of the labor court, judge in charge of the Delhi Mediation Centre, district judge, commercial courts, principal judge of the family court, and most recently, as the director of the Delhi Judicial Academy, where he played a pivotal role in shaping judicial training and capacity building. He has also served as a senior trainer with the Mediation and Conciliation Project Committee of the Supreme Court of India, reflecting his deep commitment to alternative dispute resolution. In addition to his judicial work, he has taught at the Faculty of Law, University of Delhi, worked as a law officer with Oriental Bank of Commerce, and continues to engage with the law as an independent practitioner, mediator, arbitrator, and mentor. With his rare 360-degree exposure to the legal system, from classrooms to courtrooms, from trial advocacy to judicial decision making, Sir's journey offers invaluable guidance to law students who aspire to build a career in the judiciary. We are delighted to welcome you, sir.
Thank you very much. Good day to you.
Thank you, sir. So, to begin with, you began your career as a first generation lawyer and later joined the judicial services. What motivated you to choose the bench over continuing long term litigation?
You see, I joined in the year 1991, and before I completed my law, I was doing company secretaries also. And
Oh,
it was while doing the company secretaries, it came to my mind that I should go for law. So I studied law in the evening college at Law Center 1, which was at Mandir Marg in New Delhi at that time.
okay.
And for the 3 years, I was really fascinated by law. Certainly, I started my journey as a first generation lawyer, nothing to bank upon, no relatives, nobody there to support.
Yeah.
But still, the initial going was also good.
Hmm.
I got help from many quarters. I started initially independently, and thereafter, I joined as senior, and we developed a very good relationship. As the Providence could have it, I joined a nationalized bank as a law officer
Hmm.
after about 2 years, 7 months of my practice. But when I joined there, I did not find that to be my cup of tea.
Hmm.
So after 2.5 years, though I was confirmed in service, I took a decision to submit my papers and call it a day. And I rejoined the profession. So I had to start from the scratch again. And just after 1 year, I got this engagement in Delhi University as a part-time lecturer. And that really paid its dividend. It is still paying, I must say.
Hmm.
Uh, During those 5 years of my teaching from 98 to 2003, it was rebuilding yourself, regaining your skills, and making them firm and firm. It helped
Hmm.
me so much that even many senior lawyers, they used to take my advice, especially because evidence law was my forte during my teaching days. So they used to come to me and take my advice, and they gave many cases to me also. So my practice flourished like anything. But as the Providence could had it, I was in fact during the days of my teaching was
Hmm.
bit and bit prepared towards this direction to take up the judicial career
Hmm.
as a member of the bench. I did not consciously prepare for it. And in fact, I was so immersed in my practice that I could not take out a slice of time to prepare for it, but I was already prepared by the 5 year stint in Delhi University. So it was the
Right.
first and the only examination which I had taken. It happened sometimes in the mid of 2016. In July of 2016, I got the result that now you have to appear for interview on 12th of July, I think, of the year 2016. But as the things moved, the interview was postponed from month to month, and it took almost 1 year to complete the interviews. For one reason or the other, the interview was postponed. And in June 2007, I joined the bench, and we were given training for 4 months in the academy, Delhi Judicial Academy, and I had the occasion to be a director of Delhi Judicial Academy at further stage. So this is how. So I can't say that there was any specific, you can say, inspiration, but there was a lot of perspiration. So
Right.
inspiration was not more than 1%, but perspiration, it started way back in 1998 when I joined Delhi University as a part-time lecturer. So I was being prepared in that way, and somehow the things came to this juncture that I joined the bench in 2007 and served there for 18 years. But certainly nowadays people do have an inspiration. There's a lot of knowledge, lot of information available that they can
Right.
opt for it. During our days, it was not fancy to have
Right.
information of this kind. So exams happened. Exams were not also very regular.
Mm.
So things happened in this way. So I can again, at the cost of repetition, I can say that it was 1% inspiration and 99% perspiration. I am here, and I have completed my innings there and back to
Right.
the field again from where I had started.
So, sir, to start with, you began your career as a first generation lawyer and later joined the judicial services. What motivated you to choose the bench over continuing long term litigation?
You see, that oft repeated quote that it is 1% inspiration and 99% perspiration, that came true to my joining in judiciary. As the providence could have it, after joining the bar in 1991, having some stint in law as a first generation lawyer, then I joined a nationalized bank as a law officer. Did not find it to my cup of tea, so bid farewell and rejoined the bar.
Mm.
God helped me, gave me an opportunity to serve Delhi University as a part-time lecturer. And incidentally, I was given so many subjects. Whenever any professor went on leave, I was
Mm.
given his subject. So I dabbled in about, I think, 14 subjects during my teaching of 5 years, and I set up the examination papers, so many things. So by and by, it somehow prepared me for that doomsday of
Mm.
joining the judiciary. I did not specifically prepare for it because by the time I finished my teaching for 5 years in Delhi University, I was totally immersed in work. So could not have much time to prepare specifically for this. But I think that that preparation, that groundwork was already done. I
Mm.
had so much of work by that time. By the time I appeared in the judicial service examination, it was somehow in March of 2006. And uh, I could not devote much time, but somehow I succeeded in the examination. I competed. Interviews were scheduled sometimes in the month of July of 2016, but they were postponed time and again. And ultimately, the entire process was cleared, and I was there joining the bench as a member of Delhi Higher Judicial Service in the year 2017 in the month of June. And there was
Mm.
no looking back thereafter. I completed my innings, got superannuated on 31st of May last year, and I'm here. So the inspiration, it was something inside, but it was never so manifest that I could explain it. This is the thing. I'm here. Okay.
So, sir, since you talked about preparation, at what stage should a law student in today's date seriously start preparing for the judiciary? And how did you personally balance that practice and preparation?
You see, with the kind of competition and kind of awareness we have, and kind of intense coaching that is available,
Mm,
I think the start should be from the day one. But
mm,
there has to be a method in it. I remember one story once Napoleon was passing through a
mm,
passage and it was scorching heat and
mm,
there were many casualties in his army. So he summoned his generals and asked them that what is the way out to
mm,
beat the heat. They said the only way out is that you plant trees on the way. So
mm,
when you come back, there would be trees on the way and you can walk easily.
mm,
So he said how long it will take to plant a tree and it to plant a sapling and it to become a tree. They said it will take about 6 to 7 years. He said, don't
mm,
waste even a single second, start right now. So, for a person who is in fact
mm,
willing to join the judiciary, the start should be from the day one when you
mm.
join the law. Normally, people go through 5 years course. Of course, there are some people who follow the 3 plus 3 years route.
Ah, yes.
During the initial years, your concentration would be on developing certain skills which take a long time to develop. These are reading the case laws, full case law,
Mm,
summarizing the case law, developing your critical ability,
mm,
developing your communication skills. These are skills which will require a long term preparation, developing general knowledge. So
mm,
during the first 3 years, you can concentrate on developing these skills and, of course, concentrating on your academics also. But in the last 2 years, you can come to the preparation of judicial services. Of course, now the new entrants at the entry level,
mm,
they have also have to undergo a qualification of 3 years
mm.
law practice. So for them, it's not simply walking out of the college and then straight away giving the judicial service examination.
Right.
But certainly when they will be doing practice in law, some
Mm,
of their time would be devoted there also. So
mm,
they have to start preparing seriously in an extensive manner during the last 2 years of their college, and then
mm.
every day for 4 hours study. I think that would be sufficient. Only thing is that you have to learn, you have to retain, and you have
Mm,
to ensure that you are able to put the pen on the paper. So that is the way it should start.
right. Sir, could you walk us through the application process for the Delhi Higher Judicial Services and the key eligibility requirements for aspiring candidates that they
You
must be
see, there
mindful
are
of?
there are two eligibility conditions which are very very essential. They are, one is that 35 years age you
Mm,
must have completed on the cutoff date which they give. Second is 7 years of continuous practice. Now the word continuous is very very important here. During my time, it was only 7 years of practice.
okay.
So, say you have done 3 years of practice and
Mm,
then you join some organization as a law officer. So, your license is
mm,
suspended. So, you are no longer doing
right.
practice as an advocate.
Ah,
So, that period used to get reduced. So, if you have worked for 15
mm,
years, and 10 years is practice, 5 years is some service, maybe in government company, in some PSU
mm,
or in some private organization when your license was
mm,
suspended. In total, you have completed more than 7 years, so you were eligible. But now
mm,
it is continuous 7 years. So say after doing few years, you give a break, so your innings starts afresh.
mm,
Previous practice is not counted. So, though every high court has its own qualifications, but I think in the times to come, all the high courts will adopt it because they really want the practice in law,
Right.
as an advocate and not working on a desk. So that is what they look forward to. So 7 years continuous, even if you are one day short, and we have seen many examples that people were selected, this information was not clearly given in their application forms, then their candidature was challenged, and even they were doing the training at the academy, but
Oh,
they were declared ineligible. So that is a very, very difficult situation, because you have closed your office as a lawyer,
right.
and then restarting and then facing the public queries that why you are out, maybe there was something wrong with you, people can imagine anything. So one must be very,
Mm.
very selective and careful that he in fact completes the eligibility criteria.
Mm.
So otherwise, they ask for income tax returns also, but I don't know. I mean, it never emerged that what they look for in the income tax returns. They ask you the details of the cases which you have done on your own. So that
Okay.
details is also, but I have not seen anybody being rejected for his income tax return or the detail of the cases he has done.
Mm.
But 7 years continuous practice is a mandatory condition
Mandatory.
which cannot be ignored at any cost.
And so, what does the selection process typically involve? Written exams, interviews, judgment writings, and which stage do most candidates struggle with?
You see, the selection process, the examination process is more or less the same for entry level as well as for higher judiciary. First is the preliminary, which is multiple choice
Okay.
objective type.
Mm.
It is mostly an elimination round. So if your percentile is good, you can clear it.
Mm.
Some states adopt the negative marking criteria. Like in MP, there is no negative marking criteria.
Yeah.
They may put it, but negative marking or no negative marking, ultimately it depends that how much above you stand
Mm.
than others. If you are ahead of others, it's all right. Negative marking is also, it can be managed that you can beat the negative marking also. It does hardly matter, because if you are first among many firsts, that's all right. If you are behind, even if there is no negative marking, you cannot achieve much. So it is
Mm.
intensive study and intensive preparation that is very
Mm.
essential for the preliminary. The
Mm.
mains is generally descriptive kind of paper,
Yes.
and your competition is with a select few. Uh, in prelims, the exemption sheet that is assessed by the machines, because
Mm.
either the answer is correct or the answer is wrong. But in descriptive, maybe your answer may be correct, but your reasoning may not be good. So that
Mm.
involves a little bit of subjectivity. Those papers are checked by the people who are appointed to check those papers. And uh, you can, if you have prepared for the prelims well and you are otherwise good in writing, in description, then it is not
Mm.
difficult to clear that examination. Then interviews there, interviews
Mm.
mostly it's qualifying. Of course, the marks in
Okay.
interview would add up and it would determine your seniority, but it is mostly qualifying. But of
Mm.
course, if you are last in the seniority, it is quite likely that you may not get the call letters. It depends how many people join, how many people leave after joining, because the panel
Oh,
remains
yeah.
valid for 1 year. So it's a mix of all, and people struggle with many things. I mean, if you are lacking something, you will certainly struggle with that. But mostly people find it very difficult in the prelims examination, which is an elimination round.
Okay.
There you have to always keep floating, keep your head above water, because there is intense competition there. And you don't get much time for the mains after the prelims also. Generally, you don't get much time. It may be month or 2 months, or at
Mm.
the most 3 months. So while you are preparing for prelims, you are in fact preparing for the mains also. Interview, you don't need any preparation. They mostly judge your personality. That is the one of the facet. And of course, they do judge legal knowledge also, or general knowledge also, but focus ought to be, and it is mostly on judging your personality as a judge, as a would-be judge.
Okay. Sir, since you said that the interview panel, judges your personality, from your experience as a judge and judicial trainer, what qualities does the interview board look for beyond legal knowledge?
You see, in fact, interview board should look for only the personality as a judge, because you have already
Mm,
tested their general knowledge, their academic qualities, their competitive skills, their knowledge of law, their knowledge of language, translation,
mm,
etc., in the two stages which had passed through. But still, I think we are judges, and the persons who judge a candidate in interview, they are also judges. So it is very
mm,
difficult for them to come out of that state of mind. So mostly
mm,
the questions are aimed at legal matters. They do ask some
mm,
other questions also. I remember that they asked me, one of the interview board member asked me that your name is Manmohan, so your
mm.
parents name you as Manmohan, so you must be very good. Then the other member objected. He said, first of all, you cannot put this question because my name is also the same. And second thing is that how can you say that he was very good? He's still very good. So they encourage me and they ask me certain questions. I think even if they ask the law questions,
Mm,
they are not looking for right or wrong answers.
mm.
They are looking for that you don't bluff. They are
Ah,
looking for that even if your answer is wrong and it transpires that you are wrong, you admit.
mm,
And even if you don't know the answer, you admit that you don't know the answer. So perhaps in the garb of asking the legal questions, they are
mm,
asking and judging your quick wit, your honesty, so many qualities a person should have. I think it's very difficult to illustrate all those qualities. So even in the name of asking those questions, they look at
mm,
your body language, they look at your confidence level, they look
mm,
at the depth of your answer. Maybe the answer may be wrong, but if the reasoning
mm,
is good and if you can live with it, so they look for all those things.
mm.
Generally, they somehow judge the inherent qualities by asking legal and other questions.
All right. And sir, once selected, what does the training and induction process at the Delhi Judicial Academy look like? And how important is it in shaping a judge's career?
You see, we have judicial academies at the state level, and at national level, we have National Judicial Academy in Bhopal.
Mm,
National Judicial Academy invites the directors of all the judicial academies,
mm,
maybe online or offline, to discuss what agenda they have for this year. We prepare the calendar every year. We
okay.
prepare calendar for many things, but let me confine to this subject of the judges who
Mm,
are inducted into judicial service. At entry
mm,
level, we have a training program of 1 year for civil judges or judicial magistrates.
mm.
And the focus is on four areas: knowledge, attitude, technology, and ethics.
Okay.
Earlier, there used to be three areas: knowledge, ethics, and attitude. But
Okay.
recently, the fourth,
Mm,
because that is becoming very, very important with the advent of electronic evidence, and it is
right.
a full-fledged science in itself. So they have included technology so that you don't feel alien. So training
Mm,
focuses on those four areas, and they give you attachments in court, they take you to land record office, they take you to the jails, they take you to forensic labs. So you get a first-hand experience of how the things move, how
mm,
you have to appreciate the report, what goes behind making a forensic report, how they analyze, what are the challenges which they face, what are the challenges of people who are in jail, how the jails are maintained. So what kind of record is maintained there? What kind of the total work culture you learn in this process, so that when it comes to you, you are not alien to subject. You can appreciate their good things, their challenges in a better way, and you can engage accordingly. Land records are very, very important part. Generally, people are not given training in that, but academies do give you training. And we not only give the knowledge aspect by inviting the judges as lecturers, but we invite the persons from academics, person from the technical field, paralegal people, doctors, everybody who has to contribute something to the judicial system. So you become acquainted with them, you learn first-hand things from people who have done it firsthand, and you imbibe so many things which otherwise it's very difficult, because you cannot enter into many of the institutions.
Right.
So that opportunity is given to you. You're taken. It's really 360-degree program. As a judge, you are fully equipped before you really take up the court in your as an independent member on the bench. So you sit with other judges also, learn the court craft. You may learn the law, you know the law, you can read the file, but how to conduct the proceedings, how to handle different kind of stakeholders. So this is all given that. And for the higher judiciary, the training is 4 months.
Okay.
So because they are already coming from bar and they know so many things, they have a lot of experience at their hand. And it is basically to bring in the fresh knowledge through mature people. That's why the higher judicial services are there. So they get 4 months training, which is on the similar lines, and it equips them to sit on the dais and firmly face all the things and dispense justice to the people.
Right. So you mentioned about judicial training. So how different is judicial training from academic legal education, and what mindset shift is required when one moves from the bar to the bench?
You see, mindset shift is very, very important, integral part of this thing. This is on 2 aspects. First thing, as a lawyer, whether you are coming at the entry level or whether you're coming in the higher judiciary, you basically vouch for one client. So your approach is tilted to safeguard your client. And you will do all hook and crook, interpret the law in your way. This side or that side, whether you're complainant, whether you're accused, whether you're plaintiff, whether you're defendant. So your focus is your client. So you see maybe 35% of the picture. Because maybe as a defendant, your client may be opposed to other defendants also. So you don't see the whole picture. Your case is my way or highway. But when they are there on the dais as a judge, you have to do a balancing exercise. That all the parties, you never know till the last word has been said whether who is right and who is wrong. You can't give a commentary on a movie without seeing the whole of the movie. So you are not to jump to conclusions midway. You have to hold many things which are prompting to come out. Right? So that you, not only that you are a balanced person, you appear to be balanced on the dais. Otherwise, parties may lose faith in your neutrality if you say, yes, you are right. Yes, you are wrong. So you have to hold yourself. That is very difficult thing, because whatever is inside wants to come out. Second thing is that how you treat different persons, how compassionate you are. Being compassionate does not mean that your neutrality is sacrificed, But if a person comes,
Right.
if he is late, if he has to hold his breath, and his case has been called out, his file is before you,
Mm.
let him have rest. Let me have faith in the system. And say if somebody has come late or somebody could not do some obligation which he was supposed to perform, see how
Mm.
you speak. Instead of saying that you are late, you can say that you missed his presence for a certain time and case has been passed over.
Yes.
Give him time. You
Mm.
see, nothing. You have 30 cases, 40 cases, 50 cases on board. You can
Mm.
handle. And it is being polite and being firm.
Mm.
These two things you have to balance. So before you
Right.
balance other people, you have to do balancing act to yourself also. That
Yes.
not only, you must have heard that phrase that justice should not only be done but must be shown to have been done.
Mm.
Shown to have been done is much more important than doing the justice. Nowadays, the video recordings of courts, they
Mm.
surface on social media
Yes.
day in, day out. You see, if you may do good thing, it may not be publicized. But if you are little bit departing from the norms, it
Mm.
may be talk of the town. So you have to take care of
Yeah.
that also. Now we are more accessible, more known, more within the reach of people. So
Yeah.
you must always feel that public or God as public is watching you.
Mm.
So if you work on that, I think one can mend his ways and appear to be a reasonable person as the public wants him to be, because you are the last resort for many. So with
Mm.
some control of your behavior and pressing a pause button whenever you're getting angry for one
Right.
reason or the other, and waiting for 2 3 5 seconds or taking a sip
Mm.
of water, you can send a better message to the society, because somehow during the past few years the faith of public in the institution has suffered a little
Mm.
bit of casualty. So that repair work we
Mm.
have to done, we have to do at our own level.
Right, sir. Rightly said. Sir, judicial independence is the backbone of our justice system. From your experience on the bench, how should a judge deal with external influences, whether political, institutional, media driven, or social, while deciding cases?
You see, I must say that this is the most independent institution. But I don't say that people or system does not try to put some kind of influence upon you. One is direct, that somebody known to you may come and ask to decide the case which is before you in a particular manner. It
Okay.
appears to be curt, but we can straight away say no. Or
Okay.
we can just keep quiet and then forget it.
Mm.
Whenever anybody approached me, initially it happened, I did not remember when the person was speaking, I did not remember the name of the case itself. So I dealt with that in that way. Or you can transfer a case if you feel that you are being severely approached, where you can't,
Mm.
you don't have any other option, and because you know that certain person has approached, and maybe you may be either inclined towards that person or you may become prejudiced to that person. So that is also not a good situation. You may hold certain bias against the person who has approached you. So I remember one anecdote which is very much prevalent. One day the judge came on the dais and very angry. So he addressed both the counsel. Mr. Sharma, you have sent me 50,000 to decide this case in your favor. And Mr. Gupta, you have sent me 75,000 to decide the case in your favor. Now, Mr. Sharma, you pay 25,000 more so that both of you are equal and we will decide the case on merits. That is the lighter side of it. That if you want to refuse, nobody on
Yeah.
earth can force you to.
Mm.
Maybe you may face some kind of onslaught. Sometimes they say that we suffered frequent transfers or something like that. So that is part of any job. You should not be worried about that. About other external influences which are subtle, I mean, they directly don't address you, like media trial or something happening on the social media, Facebook, etc., where the cases in courts are judged and people have their opinions. I think it does hardly matter. Sometimes people suggest that you should not read the newspaper. I said you read the newspaper every day and then you throw that into the dustbin. These are opinions. Opinions may change. Don't flow with them. Don't take any notice of them. Once you develop that habit, you read the newspaper, you read the magazines, because you can't avoid that. You can't cut off yourself from the world.
Right.
You are not living in a glass house. You will read, and maybe while reading or by hearing, or maybe there may be comments in social media on you, on your judgments. Just take that. It is one other thing in the course of the things, and ignore it. Ignorance is the best thing. Nobody can ask you. I have spent about 18 years on this site. Initially, the kind of projections I gave, nobody approached me later on. And that created a happy situation. Even people who wanted to approach, they used to watch proceedings in my case, in my court, and perhaps the way I conducted my court, that gave them assurance that they will get the justice which is due to them from this court. That is sufficient. So 2-3 years are tough. Your initial 2-3 years are tough. After that, everybody knows you, and they know that your doors are shut for any such kind of thing, and that is the end of the matter. No issue.
Right. And despite having a robust judicial framework and a highly trained judiciary, India continues to face enormous case pendency. So, from an insider's perspective, what are the primary reasons for this backlog? And if you had the opportunity to implement three immediate reforms to reduce pendency and strengthen public faith in the judiciary, what would they be?
You are very right. We count the numbers, and many reasons are given. Judge population ratio, but judge population ratio cannot be seen in isolation. Some populations are more concerned about their rights, so they file not only the cases which are good in number, but they are good in quality also. They fight tooth and nail. So just the number game is not the only issue. The fact of the matter is that I am not worried about dockets explosion. Dockets are increasing. We are deciding less, and cases are more in flow. That is because of a variety of reasons. New rights are coming, new rights are generating, new laws are coming, and Supreme Court asked the legislature that you consider the judicial impact assessment whenever you bring in a new law. Like one law, Section 138 of Negligible Instrument Act, when it came, it has exploded the dockets like anything. Now we are having so many cases on matrimonial front because value system is totally changing. People want to come out of a stale marriage. Earlier times, people still suffering, but they wanted to remain in that stale relationship because the society did not provided any opportunity to exist. Now that opportunity with the same old law interpreted in a different way, that opportunity is available. So cases are increasing. Some cases, even after 1 month of marriage, cases land in the court. So that kind of thing is happening. To me, the biggest issue is dockets exclusion. People who are not coming to courts because of the delays, because of the time lag, because of the cost involved. Cost involved, tangible cost may not be much, but intangible cost, the stress, the waiting, the uncertainty, that is taking a toll of the mind of the people. And they are looking for shortcuts. Those bhai and other kind of people for getting their houses vacated. And house goes for a song if you vacate through them.
Yes.
So the biggest reform which can be taken, that if you find that a person has deliberately filed a false case, you punish him. But that process itself is a long drawn process, the way in it has been made. If at the end of the judgment, I have been able to see that some person has taken the institution for a right, there should be only one single opportunity of hearing, and then this way or that way. Because I have already have everything. I have the documents, I have the depositions, I have everything. But we have developed a very, very elaborate procedure. So we have to come out that kind of procedure. So if the message goes that if a false case is filed and you can't go scot-free, then certainly there would be reduction in filing of such cases. It would drain out the system of such false cases, and other cases will flow very fast. And if they flow very fast, some kind of domino effect also takes place. You know that cases are getting disposed of, you also get encouraged to get the cases disposed of. So there's nothing wrong with adjournments. Adjournments have to be given because the entire business cannot be transacted in a single day. Perhaps we are looking at the problem from very, very myopic angle. We have to look at a macro level and to devise the ways that you punish the wrongdoer. If you have fiddled with the system, pay a price for it. Let it not be imprisonment, let it not be something, let it be monetary sanction which you put on that person. It will take care of that thing. I don't believe that you give a 3-point agenda, you give a 5-point agenda. One agenda is sufficient. If somebody is clogging the wheels of justice, he must pay the price. You become the Pied Piper of Hamelin and throw all the pests, dump them somewhere and cover the ground. So that has to be done. 1-point agenda and do everything. Of course, we have many other things which supplement the system, like we have arbitration, we have mediation. Arbitration, we have burnt our fingers. It's not fast, it is not expeditious, it's not cheap.
Yes.
It is very, very costly. And again, you have got the award, but again, it gets stuck up when the award is challenged. Those grounds, though they say that there's not much to challenge, but if you make very, very vast, open-ended grounds like the law, it is against the legal policy or public policy or something of the sort. I think that is a very, very wide ground. They have to somehow put that into some rational, limited grounds, and not that you open the entire Pandora's box in the name of one or the other ground, which does not make any sense. On the one hand, you say that you can't go into this thing, this thing, this thing. Those are small things, and then you open the entire sky to them. That objection will not even will cross the sky. Also, sky will not be limit. So that thing has to be done. I think this is a time to relook, but again, at the cost of repetition. It is the wrongdoer, the person who is clogging the wheels of justice. If you take him to book and take him to task, that would serve. The message would spread that courts mean business and we have to do business and nothing else. So
Beautifully said, sir. Right. Sir, but despite the enormous backlog of cases across the country, we notice that some states conduct regular and frequent judicial service examinations, while others do not. What are the reasons behind this disparity? And in your view, is simply appointing more judges a sufficient solution to the pendency problem? Or does the issue require deeper structural and procedural reforms?
I would go with the second thing, not with the first thing. It is not the number game. You can have as many people as you want, but the job will not be completed. You have to select the right kind of people. And I'm saying at all levels, not only in district judiciary, but at High Court and Supreme Court, you have to select the right kind of people. We know that how the appointments in High Court take place. They're just on reference. You have to look at the person's commitment to the cause. And maybe at the district level, you test them for their legal ability, legal knowledge, but you don't test them for their willingness to perform. Perhaps some kind of psychological test, maybe written, maybe oral, maybe both, that has to be conducted, that you induct a person with the right attitude. Of course, he is there to earn his bread and butter. Let him. When he is working, he has to be paid, and pay him handsomely. Don't pay less. If you want to have big people, pay big. Otherwise, if you offer peanuts, you will get monkeys only. But once you pay them, there must be output in both ways. On quantitative terms, that you dispose many cases, and on qualitative terms, that you really, in the name of disposing more and more cases, you don't compromise the quality of justice. But most of the high courts have not been able to make any formula for that. Many have formulated a unit area method where different type of cases, depending on their complexity and issues involved, they are given certain numbers, and you have to churn out particular, say 133 numbers or 150 to count yourself as an outstanding judge. But that criteria, I think that has been developed without any empirical evidence. That is just some arbitrary criteria which has been adopted. Maybe everybody has copied from his own neighbor. Some real criteria has to be devised so that it cannot compromise quality at the cost of quantity and quantity at the cost of quality. There must be a good balance in that. About the different states conducting examination regularly and some states not coming, because some small states may not be having vacancies throughout the year, or maybe for one or two vacancies, it may not be feasible to conduct an examination. I think during the last 7-10 years, most of the states are regularly coming out with the vacancies, and vacancies are the sanctioned vacancies. So due to retirement, due to any other reason, the vacancies are being created and regularly coming out. Of course, there is delay. They should take the examination in advance on the anticipated vacancies, rather than the vacancy becoming available, then they are coming out of their slumber, and then advertising, and then conducting the examination. So 2-3 precious years wasting in that exercise. You should have persons on training 1 year before the vacancy is going to arise, by retirement at least. Death you cannot foresee, resignation you cannot foresee, but at least retirement you can foresee. So structural reforms are required, proper trainings are required. I say that with so much of training, many judges are still grappling with the electronic evidence. They have not been able to understand it properly. And the cases,
even advocates also.
The electronic evidence has been reduced to nothing. It is better to have paper evidence rather than having electronic evidence, because they are not at home with it. So that somehow has to be done. And the Supreme Court and High Court should develop such kind of basic things, that these are settled things for all the times to come. It is not that today one judgment comes, tomorrow another judgment comes, and whatever you have learned, that is undone, and another exercise is taken. You see, it's only the paper which has been put in electronic form. But of course, there is a risk, because it is subject to very quick manipulation, and that manipulation is not obvious on the face of it. And the technology is changing so fast. So there has to be something done at all levels, maybe at the legislature's level, maybe at the High Court and Supreme Court level, so that electronic evidence does not become a hassle. It should facilitate the propagation of case. It should not become a hassle in the progress of the case. And the cross-examination on electronic evidence, they have also to be controlled. It is not that you ask any Tom, Dick and Harry question regarding the electronic evidence, and then you just throw away the electronic evidence. So that
Mm.
is a major gray area which has to be taken care of. If that is properly taken care of, I think we can speed fast the entire system. And of course, so many reforms at various levels are required so that the recruitment is timely, recruitment is proper, right kind of person with right kind of attitude. They occupy the dais as a judge, and they should have that, of course, the basic quality that they are really devoted to the dispensation of justice. That has to be.
Right. Right. And sir, you having presided over civil, criminal, matrimonial, labor, and commercial courts, how does the nature of judicial work vary across these assignments, and why is it important?
You see, you can't say that work varies too much. Judging is a concept which you have to develop. Maybe in civil, you may go on the preponderance of probabilities, and in criminal
Mm.
law, standard of proof, another standard of proof is added beyond because
Reasonable
in
doubt.
addition to preponderance of probabilities, that is,
Mm.
it has to be beyond a reasonable doubt. But I think everywhere, wherever you are working,
Mm.
your guiding force is principles of natural justice. You forget the law. You at least follow the three principles of natural justice that you hear both the sides. Decide
Mm.
after hearing both the sides. I
Mm.
think it's not a difficult task. And that you don't be a judge in your own cause. However, little bit you are interested, maybe one reason or the other. Maybe you are interested because you have a certain kind of bias or prejudice. Please don't deal with that case. Transfer that case. If you have a
Mm.
strong bias or prejudice, if you
Mm.
have subtle, that is present in everybody, some bias of this kind of that kind, and with some period of working, you can overcome your bias also. Of
Mm.
certain bias you are not aware of, you cannot help it. But that does not do much of the damage if your basics are correct.
Mm.
So the thing is that you keep on upgrading your skills.
Mm.
Second thing is that you become glued to the society, though your profession asks you to
Mm.
be little bit kind of hermit, living away from
Yeah.
the society, and you can remain glued to the society. There are books, there is social media, you hear about people, you can watch the people. It is not that you have to mix up with the gangsters to understand how they work, or you have
Yeah.
to mix up with saints to understand
Mm.
what is behind their sainthood, and how much of sainthood and how much of lack of sainthood. You can understand things. There is
Mm.
lot knowledge, information available. You can have access to that on daily basis. You can groom yourself so that
Mm.
your knowledge is there. You have knowledge of the society, your knowledge of
Mm.
the systems of the society, your knowledge of the hills and
Mm.
downhills of the society. And you can work. You can always be a good person the next day, what you were not yesterday. It's not
Yeah.
difficult.
Right, sir. And so, could you explain the transfer and posting policy for judicial officers and how one manages personal life? As you just said that, one doesn't have to be aloof completely, but how does one manage personal life alongside frequent postings?
You see, as far as Delhi is concerned, posting is not a problem, except that your traveling distance to your place of work
Oh, that.
may
Okay.
change. But I must say that our High Court has been very considerate in
Mm.
this regard. The purpose has been, the policy has been to keep you near your home, but see, depend, you are specialized in certain kind of branch, and that
Mm.
kind of case is available. That
Mm.
jurisdiction is only conferred in one of the court complexes, so you have to travel. Travel is not a very big thing.
Mm.
And I say that you should not be always looking forward to travel in your cars. If need be, you can travel in metros.
Mm.
You will know the society. You will know the people more. You will know their difficulties more. And metro will take you much faster than I have myself traveled number of
Yeah.
times in metro. Sometimes I got noticed, sometimes I did not get noticed. So to be connected with the society you can always bank upon public transport. Of course, I never traveled in metro with my coat robes. I wore different clothes. So because of the clothes, many people could not recognize me, and sometimes they looked at me with surprise. But as far as
Yes.
states is concerned, transfer is a big issue.
Okay.
But they have also developed a resilience for transfer. Generally, the transfers are made when the academic session starts. So your 3 years are over, and your transfer would commence with the academic session, so that the studies of children are not affected.
Okay.
But certainly, change of home is a big thing. It is said that Rolling Stone gathers no moss, but Rolling Stone also goes places. It is more shining. If it is not in punitive form, and if the High Court is considerate, understand your problem that, say, a person is having boards examination of his children, and if they accommodate, if they call for his preferences of transfer, and I hope that they are calling it for. So if they make a policy which treats you not as someone, but a person who has a family, who has a responsibility towards his parents, and if they consider those, if they call for his inclination, and maybe not 3 preferences, they can call for 5 preferences, and if he's accommodated in those, so it can work well. Transfer is with all the, whenever you have taken up any government job, most of the jobs are transferable. It has its good side, bad side, both. Bad side we can always control, though may not entirely mitigate it, but we can always control. And I think the high courts have developed good policy. Maybe certain lapses may happen here or there, but they are exceptions. They are not rules.
Right. And what does the salary structure, allowance, and overall benefit package look like for a judicial officer, especially at the district judge level?
Salary structure, I think that it is fairly reasonable. I never bothered, I never looked at my salary slip because the salary was coming, it was taking care of my needs. But one thing is very, very disheartening, that there is no pension.
Right, yes.
With the effect from 1st of January 2004, they have dispensed with old pension scheme. And they have introduced new pension scheme. You see, now I'm feeling the pinch of that. The pension which I will be getting is only some 35,000, 40,000 rupees per month. With that, I cannot even have 2-room apartment if I'm living on rent.
Right.
So that is not a happy situation. During working time, you have your salary, which is good.
Yes.
You have traveling allowance. You have traveling allowance is very reasonable. It is, say, for a district judge, it is 100 liters of petrol per month, which is reasonably good. You have fixed line telephone, you have mobile, you have LTC, you have complete medical. So the things work out good, but it is only when they have sucked the blood out of you and you have given the best years, the golden years to them, then that stepmotherly treatment is really very, very bad for this institution. And maybe in the times to come, it may become a source of corruption also, because you have to provide for your those rainy days. I am blessed that during my working there and during my working in practice, I am capable of working as an advocate, as an arbitrator, as a mediator, as a trainer, as a visiting faculty to the institutions, universities. So money flows in. But living on 35,000 rupees, 40,000 rupees pension a month is something which cannot be imagined. So you
That too
give
in this
me
economy.
good days, you gave me high post, but once the utility is over, you have thrown me in the lurch. So it is for the High Court, our pay commission has recommended restoration of old pension scheme, but it is for a long time, it has been pending at the Supreme Court's end and nothing has come. So hope has grown gray hair. Let us see if the hair can turn black and silver or golden. So we are keeping our fingers crossed, but this is a thing which must be taken care of at the topmost priority.
Right, sir. And since you talked about pension and after retirement thing, so after retirement from judicial service, what professional opportunities are commonly available?
See, I don't see any professional opportunities from government for 3 to 4 years now, because the Tribunals Act that has been scrapped. So it depends on government how quickly it acts and brings in that act. So as long as that act is not there, maybe there may be no vacancies. But generally, up to the age of 67 years, you are able to get re-employment in various tribunals, depending on the number of vacancies they generate. But there are other opportunities also. It is said that there is no future in any job. Future lies in the man who holds the job. Like, I did not opt for applying for any post. I had decided it. I only applied for one post, nothing heard from them. That also as a matter of routine, but I decided about 5 6 months before my retirement that I am going to live my dreams and not going to revert to 9 to 5 kind of system of job. And I'm remaining busy 25 days out of 30 days in a month. Last month, the January was busy. I went to Lucknow, I went to Ahmedabad twice in both the cities to impart training in mediation. And of course, I was paid for it also. And I have I have some cases also which I am taking care of. I don't run for many cases. I don't have my diary of that kind, which I used to have during my advocacy days. To me, 1 or 2 cases in a day, or maybe 3 cases in a week are sufficient. I work wholeheartedly on that. Some I do pro bono, some I do charge good fee. So, but how long I will be able to do it?
Right.
I will have to slow down. Now, my body will not permit in the coming years to run so much or to do labor so much. So, the state should have provided for it. That is missing, but opportunities are in abundance. You can be a teacher, provided you have developed your skills for that. You can be an arbitrator, you can be a mediator, you can be a trainer, you can be an author. Maybe not much money will flow with an author, but nobody knows if you are successful. Or you can start a judicial institution where you train people who are aspiring for judiciary. So there are so many opportunities. There's no dearth of opportunity. It depends how you want to work. If you want to have leisure days, nobody can force you. If you want to have fulfilling days, road is always available. You can walk and you never know. You never know the road which you have not taken.
Yes.
As Robert Frost said, that I don't know. The road not taken is not taken. I don't know what would have happened. But I'm happy it's 8 months since I retired. But it's equally fulfilling. That job was fulfilling. This is equally fulfilling. And so far, the compensation is flowing. God knows what may happen in future. Let's keep our fingers crossed and hope for better days ahead.
Yes, wonderful. So finally, if you were mentoring a first or a second year law student today who dreams of becoming a judge, what 3 concrete steps would you advise them to start taking immediately?
See, if they want to become judge, first thing is that have no plan B. Have only plan A. If you have plan B, then plan A is bound to fail. And as I said earlier, start from the very first day. If you want to be a judge, start living like a judge, start thinking like a judge, develop a critical thinking. You get opposite ideas, opposing arguments, and you have to call out which one will sail through. So develop that kind of thinking, that and don't be victim of your own ideas. You may get ideas which are totally opposed to your way of thinking. Be receptive to that also, right? Don't impose your thought pattern on others. You see, this is a habit which has to be developed. And that's why I say that from the very first day you take admission in a law school, you should start working on it, because some qualities may take a time to inculcate, to cultivate it, to be really nurtured. So that is your critical abilities. That is very, very necessary. That you can live. You have not to go into the debate which they show you that glass is half empty or half full. You can say that glass is full, half with water and half with air. So you should be able to develop that kind of skill that people will try to deflect you. It is for you to be clear, to come out of all kind of confusion and reach your conclusion in a way that it really matters, in a way that it is logical, in a way that it brings the justice. Maybe you have to mold the law a little. You are answering the call of justice. So that kind of thing you have to develop. For that, you have to participate in moot courts, you have to participate in debates, you have to read thoroughly, you have to read the judgments so that you can understand not just what is the ultimate churning, but the process, how the mind of judges worked. So they are very, very good judgments which must be read. And then doing things meticulously, having a disciplined approach, developing your ethics. These all practices have to be started from the day one. Of course, during the last 2 years, you have to be focused. That now you want to crack the examination at the entry level. Of course, there would be 3 more years if the Supreme Court retains that condition of 3 years. I think that it is under reconsideration on certain aspects, because I believe that one should be brought in the system at the earliest possible. It is not that you make a person to attain the age of 28 years, 30 years, then by the time he's too old to learn new things. Though the idea holds good that he must be having some
ground knowledge.
Ground knowledge of law by doing practice and understanding how the system works. But it is no use. I think person should be there at the age of 22, 23 in the judiciary so that he can grow, he can be trained. We can improve our training methods. If we find that we are not able to churn out good judges, we can change our training methods. There is nothing wrong with the people. There is wrong with the system with which we are nurturing them. We can always improve that system. We can find out new things. I think in some developed countries, if there is 5 years law course, at the end of third year, you make a choice whether you want to go into practice or whether you want to go into judiciary. Why not to introduce that kind of concept in our teaching system, that if you want to go to judiciary, we start you preparing at the college level for that kind of bent of mind, that kind of personality. So I think there is need to change the education system also, and we can be better off on this count.
Sir, it was so wonderful hearing you. Thank you for sharing your insights and experiences so openly. Your words of advice are going to inspire a lot of our viewers. You've been incredibly kind and generous with your time and guidance here. We really appreciate it, sir. Thank you so much. We wish you very best.
My pleasure. It's really through your institution an opportunity to connect with many people who may be aspiring for judiciary or they are already in judiciary. I'm not saying that my words are final words. I have shared my side of experience. Maybe someone may have different kind of experience, different kind of thought process, different kind of suggestion. And I think for a better nation, for a good nation, we can work on those things. And good wishes to all the aspirants who are really striving for that post. But it is not the post; it is a baggage of responsibilities. So they must be prepared for that also. So good luck to your institution, good luck to you, and good luck to all people who listen to this podcast and have something to learn. Bouquets and brick pads, they are invited. If they have find it good, they can share their views. If they have found something missing, something off the mark, and something which they want to contradict, that is also welcome. We grow from those things. Thank you very much.
Thank you, sir. Thank you so much.